Court does call the case People versus Dylan Chapman.
Your Honor, Alexis Pluma, Assistant Public Defender, appearing with and on behalf of Mr. Chapman. Mr. Chapman, could you state your name for the record?
Dylan Chapman.
Thank you.
And Your Honor, today's the date text up for preliminary examination. I understand there is a bond violation. However, also at this time, people are unable to proceed as to counts 1, 2, 3, 4, and 5, and would ask for count 6 and 7 to be remanded down to district court.
So you're unable to proceed on 1 through 5.
Correct.
And would like 6 and 7 down. Got it.
Correct.
Counsel, you're moving to dismiss counts 1 through 5.
Yes, Your Honor.
Continue to defendant's not guilty plea as to count 6 and 7. I set this matter for pretrial.
January 29th at 10:30 for Judge Simpson.
That date might change. There's an in custody. We'll see, but you got the 29th right now, correct?
Yeah.
Got it. What time? 9?
10:30.
10:30. Before Judge Fresh Hour. As to the bond violation.
Yes, Your Honor, I have had an opportunity to discuss the violation with my client. He has provided me with an explanation that he feels comfortable with me sharing with the court. This was reported as a hit and run accident. Mr. Chapman states that the complainant in this case was using his car, which she had reached out to his mother and asked if she could borrow because hers was either broken or not able to drive in the snow. He states his mother gave her the keys to the car and allowed her to use it. And then Mr. Chapman states that at some point that night, his mother called him and let him know that the complainant had been involved in a hit and run accident with his car. He tells me that he did go to the scene of the accident to try to check on his vehicle, and that at that point, the complainant was not actually present. It's unclear to me in the report at what point in time the police made contact with the complainant because it was a hit and run accident. I'm not sure if contact was made at the scene or later on, and there's not a whole lot of detail there. So Mr. Chapman is asking that the court consider keeping his personal recognizance bond in place, given that explanation, and potentially setting for a pretrial and bond violation combination in front of Judge Fresh Hour, so that if there is more detail that needs to be provided, Judge Fresh Hour could consider that.
This is where things start to fall apart. The defense is trying to present a clean, logical explanation, but the judge is focused on inconsistencies. Legally, bond conditions are strict, especially involving contact with alleged victims. If the court even suspects a violation, that alone can justify revocation. And here's the key issue. The defendant's story doesn't fully line up with the evidence. So ask yourself, does this explanation sound believable, or is the judge seeing something the defense hopes you don't notice?
Your Honor, at this point, I have concerns given the nature of that bond violation with his wallet, his other property being in the car. He's not there. I would have concerns about contact with the victim, being there with her, especially given the nature of the charges. At this point, I would ask that he be remanded on the bond violation.
Your Honor, again, the only thing I will add is that Mr. Chapman explained to me that his wallet and other items were in the car when his mother provided the car to the complainant. So again, he's just asking that the court consider. Yes, Your Honor.
That his wallet, ID, and all of his everything is still in his car.
Yes, Your Honor.
And she.
My understanding is that the car was supposed to be returned to his mother soon thereafter, and that Mr. Chapman said it was okay to leave his wallet in that case the complainant needed to use his debit or credit cards.
So how close was he when this vehicle crashed? Because they have him one driveway over.
Yes, so Your Honor, he states he did go to the scene of the accident after his mother told him that there was a hit and run crash to check on his vehicle. However, it's unclear to me in the report, and based on what Mr. Chapman is telling me, at that point in time, the accident had already happened and the complainant was no longer there, and he was just going to check on his car. So again, I'm not sure because it's unclear in the report.
How do I
whether-
know the complainant's not there if she had the car? From this defendant?
So the complainant's not at the scene of the accident,
Yeah.
right? We don't know. And I'm saying that it's unclear to me when contact was made with the complainant, at what point in time.
I hear you, but none of that makes any sense to me because it almost seems like he's with the complainant, the vehicle crashes, she leaves, and he's still there. That's why the only thing that makes sense as to why his wallet, ID, all of that stuff is still there because he was in that vehicle when it crashed.
And that is not the explanation that he is providing.
I get that.
Yeah.
But none of the other part makes sense. Well, I'm not. Anything else?
No, Your Honor.
I think when I look at everything that the defendant was having contact with the victim in violation of the bond conditions in this case, and based upon what was said, at this time, I will move his pretrial date up to January 15th, 2026. That's still at 10:30.
Yeah.
January 15th, 10:30. But at this time, the court's going to believe that there's enough evidence and to indicate that there's been a bond violation. I'm revoking the defendant's bond. The defendant is remanded.
Good afternoon, Your Honor. James Fifelsky on behalf of Michael Donner, who's to my right. Please state your name.
Michael Donner.
Your Honor, we're ready to proceed with exam on this case.
Your Honor, at this time, if you are unable to proceed as to counts 1 and 2, ask for count 3 to be remanded down to district court.
We move for dismissal of counts 1 and 2. Now, I would like to address bond on count
If
3.
it's going to be that same argument, we're going to have a problem.
Well, it's slightly, Your Honor, because of these
Counts
circumstances.
1 and 2 are dismissed. I'll continue with not guilty plea. What is count 3? What do you have as count 3?
Domestic violence, person offense.
That's what I've got too, Judge.
You look at this. See what I'm saying?
Yeah, I see that.
I know. No,
This is wrong.
that's wrong.
This is wrong.
Those 1 and 2, and it's a DV. They never included count 2. Well, no. Yeah, they never included the real count 2. And so count 3, sorry, got it. Count 2 was interference with electronic communication. Actually, there it is. It's right there, but they got it entered there wrong. Can you check, did this come directly from JS? Can you check what JS has?
This is a separate document by the clerk's
Right.
office. Not-
Right, so check to make sure JS has a 3. Because otherwise they're gonna have to correct something. I'll continue the defendant's not guilty plea as to count 3. Set this for pretrial on before Judge Freshour, January 15th, 2026. At what time? 10:30. Before Judge Freshour. As to bond,
Your Honor, is that at 1484 or 3?
it's a 1484 case.
Thank you, Your Honor. Your Honor, as to bond, I would ask, given the circumstances that 2 felonies were dismissed, and this is a unique situation in terms of, I think, much more hardship to my client's family, including his wife, than to him himself. His mother-in-law has reached out to me to beg me to try to get him out of jail to take care of this family. His wife is a stay-at-home mom. He's the sole breadwinner. Even if she has to get a job for the next 3 weeks, she's got to pay extra daycare expenses to get these kids daycare, because otherwise she would be taking care of them while my client's out working. I just spoke to his mother, who said he could reside with her in Chelsea. I've got an address. I'd ask the court to tether him to the address, allow him to work. The court can assess his whereabouts and ensure he doesn't violate anything. He has never failed to appear at court. He turned himself in on this original warrant, I believe. And I understand we had a bond violation before, and I would just.
Well, 2 of them. It's not just one.
I
He just doesn't
understand.
think he has to abide by the court's orders. That's the problem.
Well, I don't think it's that. I think that he had poor judgment in terms of how he went about what he had to do just to get some things and see his kids. And I understand it is a violation. But he has now spent the last 12, 13 days in custody. That certainly sends a strong message. And just, again, we're talking about Christmas time. And he's got 5 young kids who rely on him to take
I
care
don't
of
know
their
how many
financial
women are going
needs.
to die over the holidays from somebody that's a domestic abuser either, Mr. Fifowski. So I don't think we ought to be using Christmas time as some type of mitigating factor.
Well, I would just ask, given the fact that it is but given the fact that, yes, the young children look at this as a special time, and I get it. My client is the one who made whatever decisions he has, but he's certainly willing to do whatever the court requires of him to ensure his appearance and safety in the community.
Response from the people.
Your Honor, at this time I would object. It was 2 clear bond violations. He was given clear instructions and arraignment not to contact the victim. It was set for a third-party contact about child care. He broke that, and then he was at the residence. And I mean, it can't be any more clear. If he's seen leaving the residence, he was told not to do it. So I have concerns he can't follow court orders because he broke 2 of the conditions he was given in arraignment. Almost immediately after arraignment. The first being the calls, and then after he gets out of jail, bonds out, he goes right to the house. So at this time, I'm going to object because I don't think he can follow court orders.
His bond at this point is sitting at revoked. I will grant him a bond on this case. I'll grant him a $50,000 10% bond. Same conditions apply. I'll just say this: if you don't listen to him and you get before Judge Freshour, you're going to have heck to pay. You think this was rough. I would indicate that there will be a GPS tether prior to release. That GPS tether, I am not going to give a release to work. I'm going to let Judge Freshour make that decision as to how far out he can go and what he can do, because he just can't seem to follow anybody's instructions. So I think it's probably better that it come from her. So it's going to be a GPS home confinement and with no release for anything at this point until he receives permission of the court to do so.
Thank you, Your Honor.
Thank you.
Please, most honorable Justin Andrews, EG 1445, without Mrs. Marion Jones.
Oh, sorry. All right. Your name, sir?
Marion Jones.
All right. What are we doing?
Yes, Your Honor, after talking with my client and an additional consideration, my client is going to waive his right to preliminary exam and have this matter bound over to the circuit court for additional proceedings.
That is my understanding as well.
Sir, you need to face me. You're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 5 counts. Counsel, you acknowledge receipt of the information, waive its reading,
Yes, Your Honor.
and how does your client?
This case highlights a critical truth about the justice system. Your actions while out on bond matter just as much as the original charges. Even without a full conviction, violating conditions, especially involving potential victim contact, can immediately land you back in custody. The judge didn't just rely on what was said, but what made sense based on the evidence. And when the story didn't add up, the decision was swift, bond revoked. It's a powerful reminder that credibility in court is everything. Once that's questioned, outcomes can change fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping. Courtroom breakdowns.
Plead.
Not guilty, Your Honor.
All right. Defendant having waived formal reading, pleading not guilty, court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set for
January 7th at 1:30 before Judge Conlon.
January 7th, 2026, 1:30 before Judge Chapman. Bond in this matter will continue.
Thank you, Your Honor. Have a good day, you and your staff. Happy holidays.
And to you, sir.
Thank you, Your Honor.
Thank you.
Can I approach, Your Honor?
Yes.